All right, welcome back. Let's continue with a few remarks on the first hour. Let's take one step back to the technical legal requirements of the transferability of shares, and that is that in almost all jurisdictions the method to control the known investor owners of a corporation, there are additional technical requirements for the actual transfer of a share. And in continental European countries, that additional requirement is quite often that you have to pass a civil notary as an agent of the state to actually conduct that transfer measure. So other than with chairs and pencils and glasses, you cannot simply send an email to your buyer and say, here are the shares. And that is done because of the need of each corporation to know at the key moments, for instance at the annual meeting of shareholders, who are shareholders and who are not. So the basic mechanism is that after the transfer of the shares, that transfer is registered in the shareholder register maintained by, in most jurisdictions, the board of the corporation. And to avoid that someone messes up and that there are multiple claimants in terms of owners, pretty heavy measures are introduced in legal systems with high transaction costs from an economic perspective, that such a transfer needs the stamp of a civil notary. Well, how does it work on a trading platform? Well, then there are then there is a sort of trick applied that the share is translated into a certificate, and that means that then the certificate, that is one of the options, and one of the options is that then the certificate is the economic side of the share, so that it is representing the certificate the economic rights connected to the share, being the dividend, and that the voting rights remain in the official shareholder, and that is then in the Dutch jurisdiction a foundation, and in other jurisdictions similar arrangements. So that is one thing. The other solution is that with specific stock market laws, that state supervision, symbolized in the Netherlands with the civil notary, is replaced by a supervision mechanism in that trading platform, in the New York Stock Exchange, in the Amsterdam Stock Exchange. So that the certainty of who is owner is under the control of that the market regulators, and that is then translated to software programs. So the requirements of the supervision by that stock market board is simply with artificial intelligence translated to a computer program, and that facilitates the transfer of ownership within a second times 1,000 times of the shares of Shell, etc. And that means that if you are interested, and a few of you were, in fintech, that is then one of those areas you could run into, that you are with computer software engineers in one room trying to create the new version of the supervising rules of the stock market board into a software version of it, so that you can trade electronically. One way or the other, the goal is that the corporation knows who the owners are. And if you have millions of potential investor owners, and that is then quite a administration to keep track of who is my owner, and that is an addition on the last hour. And then we move to chapter 7, the fundamental changes in the light of transferability of shares, and I would like to attract your attention to the 4 perspectives. So the individual as investor owner, for instance, has a interest in the, let's call it the transaction, and it's quite often called a merger, but that is not necessarily the proper word. The individual has a financial interest that his previous investment in the legal person is kept at a value level at least comparable to the moment that he or she stepped in, and then if there is sort of transaction, that there is an additional return on investment. So that is the perspective of the individual. And where it comes to the corporation, that is nicely addressed in the chapter, then the board wishes, and we see examples every day in the newspaper, to foster the growth of that corporation and to expand and to conquer new markets and new products, etc., etc. And then you know the difference between autonomous growth and growth by acquisition. Autonomous growth is that within one corporation you hire more personnel, and that personnel works harder, and then you get more volume. But last 100 years, a growth through transactions or mergers is easier, because then, for instance, Philips can purchase Vauxhall and Opel and immediately doubles in size. And then the word merger is confusing, because you could say, do I have another color? That the literal meaning of merger, if you have corporation 1 and then corporation 2 with shareholders, that a merger literally means that they are then one corporation, one piece of paper. And there are sort of legal technicalities we will discuss in chapter or in week 6. But normally, this is not how it is done. Normally, you have a corporation 1 and you have corporation 2. These are the shareholders. And then merger means, in the day-to-day, that all these shares are transferred in ownership to corporation 1. And then these shareholders are gone, and corporation 2 is just a subsidiary of corporation 1. And then all the shareholders are happy on the Bahamas with a little bit additional cash. So I would like to clarify that the word merger means, in 9 out of 10 situations, that the shareholders of corporation 2 sells the shares to corporation 1. So that is basically the starting point. And then obviously, if there are other power balances, etc., there are other options. But please think of scenario, let's call it alpha. Is that a Greek letter you're familiar with? Okay. Then the government has an interest in this, among others, based on taxation. So in certain jurisdictions there are taxes involved if you realize a certain return on investment by selling your share. And in other jurisdictions, for instance in the Netherlands, that is why we are a corporate paradise, there are no such taxes on the increase of value of your original investment, making the Netherlands a friendly corporate environment. And then we in academia are trying to reflect on all these matters, but please realize that there are these sort of three main actors involved even in this topic. And then if you look at mergers as in alpha from the transferability of shares perspective, then it is one of the fundamental changes. One of the fundamental changes of who? Of Corporation 1 and Corporation 2. What is the fundamental change for Corporation 1? The to-be mother company? Well, that the board of Compagnie Mum, for instance Citroën, a French corporation, all of a sudden is also the board, effectively, of a completely different corporation, in this case Opel and Vauxhall. And that means that if you are a shareholder of Corporation 1, then at the annual meetings, where you have to make decisions, you are not in a sort of French context deciding on Citroën and Peugeot, they're one company, but all of a sudden, half of the time is consumed by decisions of this German and UK and all kinds of other country corporation. And so fundamental change in decision making, fundamental change in span of control, fundamental change in financial sense. All of a sudden, the balance sheet is twice as big. So moving from 100 plants to produce cars, you have 200 plants. And then, last but not least, that is not that much addressed in this book, there's a fundamental change for the employees, because you don't need a degree in economics to figure out that if you move from 100 plants to 200 plants, you may close 30 of them, and then you can produce the same amount of cars with 170 plants. And that saves costs. And saves costs means that those employees of 30 plants that you are about to close are at home. And then we, after portraying and framing a merger as a fundamental change, as a next step, it is interesting to see what are the other fundamental changes. And here we move from the simple corporate law reality of one shareholder, one corporation, one board, etc. We move to the complex appearance of corporate law in, for instance, the corporations you discuss in the midterm exam. What are, in this slide, other fundamental changes? Well, the first one is that you change the articles or incorporation, also known as the charter. So, in lay terms, the house rules, where in the charter fundamental decisions are laid down, as in how many shares, the powers of the managers, and the powers of minority shareholders, and all kinds of agency problems are partly codified in the charter, up to and including, as we saw in the previous hours, the limited liability of a board member, which is further limited by a sort of guarantee of the corporation towards that board member. The second very important fundamental change is the so-called issuance of shares. And that is fundamental in the light of the following, that if you have two shareholders of a corporation, let's use other figures. Let's use, they have 16 shares each. And here's the board. Why is this moving? Issuance of shares is typically the most important move to acquire further capital for growth. Either autonomous growth or capital for corporation 1 to acquire all the shares of corporation 2. And the primary tool to acquire that finance is to issue shares. And then for, if that is also 16 each, then here in situation 1 we have 32 shares, and here we have 64 shares. And why is this a fundamental change? Because from the perspective of A and B, the original shareholders, they lose half of their voting power. Because in the first instance they were with the two of them, so they have 50% say in the decisions they are able to make. Appointment, dismissal of directors, for instance. And after the issuing of new shares, they only have 25% of the say. Voting right. 2, where it comes to return on investment, also known as dividend, they have to share the excess profit after determining the financial statement with 2 more investors, diluting the dividend and diluting the share decision power. And here you have various, and we will discuss it in a minute, and then the mergers we discussed. And then a very funny thing happens. From a corporate law perspective, we are quite emotional about those first 3 fundamental changes, but where it comes to big projects, or where it comes to huge debt financing arrangements, the corporate lawyers are quiet. So if Shell decides to build windmill parks on the North Sea, then there are no legal arrangements in the board and in agency problem thinking to look at that. Or if AkzoNobel discusses a new loan from the ABN AMRO Bank, then there is no involvement of all the considerations we have where it comes to charter management, share issuance and mergers. So the funny thing is that in corporate law, selected fundamental changes are accompanied with all kinds of legal arrangements, gentlemen, and others are not. Where from the perspective of the corporation, it could be equally fundamental. Because if Shell moves to windmill parks, that is sort of fundamental move away from fossil fuels, etc. And that means that from the board perspective, the decision to expand can take 2 forms. You could either issue shares or change your charter with all kinds of interaction with shareholders, or you could just go to your bank without mingling in of your shareholders and try to get the cash. And those are typically decisions in boards that economists are involved in. Because there you calculate with Excel what brings in the cash in an easy way. And so here you see the sort of interaction and the skills you have, because typically with a bank loan, we will discuss right now, comes with annual interest, 9%, and the equity financing comes with dispersed, or how do you say that? That the return on investment is only after you have your earnings. And that is risk bearing. So there are many, many differences, but that is very important to see. Well, and then the conceptual framework is the tunneling. And I like the word tunneling because that comes from the Cold War era, where valuables of the communist countries were smuggled to the West through a tunnel. And that is called tunneling. And that is a conceptual word chosen by one of the authors of this book as an umbrella term for all those transactions where value is misappropriated, where the actors are receiving more value than they are entitled to. And the examples are no, those are not yet the issues. Well, and then we talk about self-trading, so that the corporation trades with the shareholder. And the problem is, for less favorable terms on the side of the corporation than a other contracting party would receive. 2, that the board managers are making deals with their own corporation for less favorable terms as a regular outsider would receive. And where is the tunneling? Well, that because of this insider position, the manager or the shareholder gets excess value and can cheat, so to speak, other shareholders through the misappropriation of value. And now a third word that is used to describe the same is opportunism. That managers opportunistic, and one of the easiest examples is granting you a excess salary, because the board decides on their own salary, unless in a charter other decision-making mechanisms are introduced. Before we touch upon the regulatory strategies to combat this tunneling, we need to look at the regular alternatives, and one alternative is collective action, so that those shareholders ABC who want to target shareholder A who expropriated value with a deal, that those other shareholders could sue that shareholder and, based on the concept of tort, ask for damages. But that is obviously 10 years later, and in terms of transaction costs, an unattractive alternative to combat tunneling. And we have problems with asymmetric information, meaning that, well, B, C, and D do not know that their value is taken away by A, or the so-called contractual incompleteness, that all the contractual arrangements, and the charter is a contract in itself as well, are incomplete, meaning that specific, or let's put it the other way, that the action of A is not forbidden by contract. And you see that also in ordinary society, that people say, well, it's not forbidden, so I'm allowed to do it. So incompleteness means that you did not agree that you would not do it, the tunneling. Well, and to avoid that, we have those regulatory strategies. And discussing regulatory strategies, I would like to point at Schedule 2.1 in Chapter 2, where there is a sort of matrix. And what I like is to sensitize you to those two key considerations being ex ante, ex post. If you look at issues, you could, prior to the issue emerge, take measures. For instance, with agency constraints, you could make rules that apply to agents so that they behave in a certain way. Or where it comes to the appointment rights, that prior to the appointment there is a selection mechanism. Or where it comes to decision rights, for instance for issuing shares or for mergers, that ex ante, so prior to the transaction, the shareholder has decision right, initiation. And the alternative is ex post. And ex post means that there are no rules, so manage as you like, invest as you like, and only afterwards, and then you have to picture a court of law, so there the government pops in, because they run courts of law, that those courts of law assess the transaction based on the angles we discussed. This reasonable standard manager, is this a normal managerial transaction or not? And that is obviously a much more liberal approach. And so here you potentially see, if you want to have caricatures, that continental civil law Europe likes the ex ante rules in the hope that people behave, and the more liberal, if you wish, common law systems, UK, USA, believe that ex post standards could also help. Why? Because that is case law, that if then there is such a judgment assessing a certain issuing right of a board or a merger, then future board members and shareholders act according to the standards articulated in that case. So there is a circular effect. So ex post is ex post for this transaction, but ex ante for future transaction. And there you could argue that if you rely on a strategy where you say, do as you like, behave as a normal entrepreneur, and if you are exceeding normality, you incur non-contractual liabilities, tortious act, unlawful act, then you will hear from us. And then you only end up with the standards of issues where people really have issues. And the disadvantage of rules ex ante, look at the Companies Act of the UK 2006, that's 1,000 pages. So that a legislator thinks of all kinds of issues and make rules. And out of that 1,000 pages of that one act, one statutory act on corporation, academia should count, but I guess that 55% is never used. And so then you have a lot of investment in rules, and you know, lawyers read those rules, so tell all those entrepreneurs, well, we have this rule, and we have this rule, and we have this rule. And so then ex ante rules increase transaction costs to establish a corporation, because you have to listen to 1,000 potential rules by your in-house lawyer before you can start your enterprise, as a matter of speaking. And so I would like to, and there's an abstract view on corporate law, a scholarly view, and this is the opposite of the quick and dirty rules of how to establish, etc., the business law approach. Yes, question?
It's not also so that it is neglected because the charter is able to be surpassed by proxy votes, and proxy votes you can be bought.
Yeah, so the question is that based on the legislative foundation in the Articles of Incorporation / charters, you could tailor make your individual corporation to your own desire, including that you could limit certain decision rights of shareholders via proxy, etc., etc. So that's definitely something we will discuss in week 5 when we discuss the establishment of a corporation. But good question. So here we discuss the default system. So if you get a default corporation, and if you dislike that, like managers, they dislike personal liability, so they make sure that their corporation pays for it through the chart, as we saw earlier. Well, 2 fundamental changes highlighted. Dilution of dividend or dilution of control, we discussed that. And then we have 2 agency problems. One is the shareholder, the manager. The manager wants to issue new shares because that brings in capital without monthly interest, where he can grow. So from the board manager's perspective, the idea is to trick your shareholder, to make your charter in such a way that they do not have that much decision rights. And that means that there the agent manager could tunnel value from the shareholder to the corporation. So tunneling is not necessarily for personal gain, and that could also be relatively from an existing shareholder to the corporation. And the other one, very importantly, is obviously minority shareholders. If you would like to issue new shares, so increase the amount of shareholders, and you start with a 75% percentage as a majority shareholder, it takes a while until your personal dilution reaches 51% or even less. But if you start with 7% stake in the shares of a corporation and it starts diluting, then you reach quite early the 1% and corresponding diminishing of voting rights and dividend rights. So there you have those 2 aging problems. And what are then the solutions? Very simple, and then I come to your question. The solution is decision rights of all those shareholders, or even the right, like in Germany and the Netherlands, that if such a issuance occurs, that you can tell the new majority shareholders that you cannot even tell them, but that you can force them to purchase your shares. That you say, well, such a dilution I don't want to accept. Here are all my shares, and you take out the money and start a new investment. So those are the 2 key rules. So decision rights and the standard that you could be bought out. Yes, the question.
No, sorry, I wanted to ask, when you dilute the shares, your dividends remain the same.
So the question is,
The dividends stay the same when
the dilution of the dividends. Well, obviously it depends. So if you have a linear mathematical approach, then the dividend of 32% is 3.2, let's say 10%, and then the dividend of 64 with 10% is 6.2. So then it is not diluted. So from a mathematical point of view, if the return on investment or the profitability of the corporation remains the same, then there's not necessarily dilution of dividend if you issue new share. But the key thing is that with the collected cash out of the, and here we have an initial public offering, and so one of the issuing could be that that new tranche goes to the stock market, then everything changes. So the profitability changes and all kinds of other parameters change to the extent that you do not end up with 10%. And so it is, good question, the risk of dilution. Is that the answer to your question?
Yes. Thank you.
Good point. Well, and then the mergers forms surviving corporation or the emerging corporation. So if two companies create a new one, you have a emerging corporation, and then alpha, if the corporation ends up within the group of the other corporations, that could be one of the versions of surviving corporations. And so this is just to sensitize you. We will discuss it in week 6 on the various variations. Because there's an additional one, I just dropped the name, that is the asset transaction. So then the corporation is taken away, and you just bring in all the cash and the debts and the plans and the employees. And then the corporation disappears. The issue is, again, tunneling, similarly to issuance, because if you arrange this, for instance, based on board activity or activism, then those shareholders that leave the picture might end up with a lower value than they could have had. Why? Because in the whole process, those in charge could influence the information, the design of the annual statements, the due diligence package where the corporate information is gathered, and so forth and so forth. And so there you could have a misappropriation of value of the disappearing shareholder. But we have also a reverse picture where the so-called I have a blackout. The investors equity investors, the what's the name? Help me. Warren Buffett, who okay, those activistic shareholders. Well, the private equity investors, but then there's a sort of negative name for them. Well, will pop up. But those activist shareholders, 10%, 12%, who start to dominate the shareholder meeting discussions and start to instruct managers, like with the case so connected to hostile takeovers, or instructions to split up the company. And there you could have a reverse tunneling, where that minority shareholder is getting unequal value compared to the loss of value in terms of externalities and jobs lost, etc. And again, here we have the same problems. Shareholder managers. So either the managers in the driving seat and the shareholders are sort of exiting, or vice versa, that those activist shareholders, up to and including dismissing boards and appointing their own friends to split up the company and sell the bits and pieces. Majority, minority again, and the non-shareholder constituents as described in the book. Let's move on, because let's reach an interim conclusion that we have now the 5 principles on our radar, and we are ready to analyze the midterm assessment paper companies along those 5 criteria, literally meaning that I expect in the presentation that you address the legal personhood. Where is it, the headquarter, and where are the 200 others? Who are the owners? Are there dominant shareholders, or is it dispersed million of shareholders? Management structures in terms of the legal setup or in the organizational setup. When it comes to the limited liability, are there clauses like with ExxonMobil that even limit the limited liability of board members? And how does it work out? Are there cases? One of the case studies upcoming Thursday is on Siemens, where we have liability of board members because they exceeded with the gasoline engine scandal. They exceeded normal management and they were put on trial and civil law cases. And last but not least, all those mergers and acquisitions. So as interim conclusion, these are the 5 basic principles of corporate law. And then last but not least, and that is very familiar for you, assets and finance as one of the first additional topics. Assets are all the tangible and intangible objects, in lay terms, property of the corporation, and finance, so and assets are on the left side of the balance sheet, and the finance is how is it financed on the right side of the balance sheet. And let's say a few things on that. Here we have again ExxonMobil, tangible, intangible, movable, not movable, current, non-current, all kinds of accounting terms, but ultimately boiling down to tables and chairs. And then we have 2 perspectives. We have the perspective of the economist, that is, with what type of minimum arrangements, deposits, monthly repayments, final payments. So it's sort of life cycle approach in relationship or in communication with third parties, banks or equity owners, etc. And then we have assets and finance from a legal perspective. And what is the legal perspective? The legal perspective is that the acquisition of an asset is a purchase deal, as with shares. So if you purchase a plant, you purchase a plant. That is offer and acceptance, and 2 crucial ingredients of that contract law. That is what plant and how much do I pay. And the same applies to debt finance. Debt finance, not to be confused with equity finance. Debt finance is also a simple contract. And the contract is regulated by local contract law. And contract law says offer and acceptance with 2 ingredients. What is the amount of the loan? And how much do I have to pay? Also known as interest. And then with a contract on a loan, there's a third, gentlemen, there's a third clause, and that is when should I repay the loan? Because it's a loan. So from a legal perspective, all those courses you have and potentially have in your master phase on finance is reduced to 3 clauses. What is the amount I get? What should I pay on interest? And when should I repay? That is all it takes from a legal perspective. And I like to emphasize that quite explicitly because that puts sort of finance in a sort of perspective. And all the other aspects, part of you will end up in a bank, as indicated, as a desired job. Then, in the offer and acceptance, you obviously want to know where will my money be used for. For instance, to purchase another company. What are the alternatives? So how high can I set my interest rate compared to the alternative of equity financing? What is the risk that they will repay me in 10, 20, 30 years? Or repayment in corporate fields means refinancing, so that there will be a next bank taking over the loan. And all those considerations of the lender are of a commercial nature, not of a legal nature. and commercial nature means risks, alternatives, the price, the interest rate, etc. Since the assets and the finance is the sort of key ingredients from the entrepreneurial perspective, I like to call this additional four, or I like to start the additional four aspects of corporate law with assets and finance. But then the rather disappointing sort of message is that it is from a legal perspective rather easy. I repeat, assets are chairs and tables, and finance is just, where it comes to debt finance, a simple contract of loan of money. Ladies and gentlemen, I would like to draw your attention to the workshop questions, and that the versions of the questions that are applicable to you are in the course description. So I have to amend these slides, so don't read these slides. They're a little bit similar as last year, but I developed better questions in the course description. So next Wednesday this text is on the workshop slide. So that's one household message. And then in the workshop on Thursday I invite you to, for instance, case study D, ExxonMobil. How is the purchase price paid and by who to who? So that's the question. And then your homework is to dive into the corporate information and other sources of information on stock markets and Reuters and Bloomberg on that transaction. And then it is about the substance of the transaction. So I don't need a copy of the contract because that is not available online. But let's say the story of the transaction is good enough. And that relates to ExxonMobil, where Exxon purchased Mobil or Mobil purchased Exxon, or they merged into a new corporation. That's the question. So how's the purchase price paid and by who to who? And Siemens, that relates to that corruption scandal of the gasoline engine. So figure out what was the scandal and what are the sort of liability consequences. And then last but not least, Airbus, the airplane manufacturer. What are the three biggest assets of the Airbus group? So go to their financial statement. And what type of financing are with what type of financing are these and other assets financed? So look at the right side of the balance sheet. So there I test, ladies and gentlemen, your course accounting, which is crucial for now and for the workshop and for you. Last question. Ladies and gentlemen, thank you for your attention. See you on Thursday, twice. Bye-bye.